What if one team, and one team only in a baseball game, got an unlimited number of strikes and outs in order to give them a chance to score the winning run? What if a football team, and only one football team, got an unlimited number of downs to reach the end zone to score the winning touchdown? And what if a bank got an unlimited number of chances and an unlimited amount of time to file foreclosure lawsuits against you again and again to take your home from you? Well, I'm Florida foreclosure defense lawyer Michael Wasylik, and today I'm here in front of the Florida Supreme Court. And today we're going to be hearing argument on that very question in the case of Lou Bartram versus U.S. Bank. Now, what the court's going to hear today is a question that was decided called the statute of limitations. And what the statute of limitations means, it's a time limit for a bank to file a foreclosure action after the cause of action accrues, which means after the final piece of the puzzle falls into place, which gives them the right to sue for foreclosure. Now, the issue is pretty clear-cut in every other area of the law. If you have a lawsuit against somebody, you have a limited amount of time to file, and it can be anything between 1 year to 5 years under Florida law, and there's a couple outliers where it's longer than that, but for the most part, almost every lawsuit is within 5 years once the injury occurs. However, foreclosures right now are not like that. It used to be considered that there was a 5-year limitation, and in fact the statute, the law passed by the legislature is very clear on that point. But a decision by the 5th District Court of Appeal in April of 2014, Bartram, or U.S. Bank versus Bartram, said that a bank basically has an unlimited amount of time to file a foreclosure lawsuit against a homeowner, and an unlimited number of chances, effectively, to take the home. Now, the 5th DCA did say that that question was so important that the Florida Supreme Court needed to hear it, and today we're here, it's November 4th of 2015, and today we're here in front of the Florida Supreme Court. They're going to hear argument on that side of the case. Obviously, we're here, we're part of the legal team representing the homeowner, Lou Bartram, and the bank, of course, has its own army of lawyers on the other side prepared to argue the case. And it's already fully briefed. The only thing left is for the court to hear the lawyers discuss the case in front of the court, answer any questions the court's going to have. We don't know yet what the court is going to do. We don't know yet when the court will make its decision. But one thing we do know is that when you understand the question in the light that I asked at the top of the video, which is, what if one side and one side only had an unlimited number of chances to win the contest? Our guts tell us that's simply unfair. If it was a baseball game, we'd know it was unfair. It wouldn't be worth watching, and it wouldn't be worth playing. If it was a football game, same thing. It wouldn't be worth watching, and it wouldn't be worth playing. And it would be fundamentally unfair for both sides. For both sides. Court is no different. Court is no different. Although it's not a game because people's homes and livelihoods are at stake, it's more serious. And fairness in that process is even more important than a baseball game or a football game or any kind of sporting contests. Fairness in the court system, even-handed opportunity available to both sides, is the cornerstone of the integrity of the judicial system and the independence of the judicial system. So if our courts want to remain to be fair and open and balanced for all sides, if liberty wants to be blind and weigh both sides equally, then the answer to today's question has to be no. There have to be limits. There have to be limits on the bank's ability to file and try again, to fail an unlimited number of times and try again. There has to be some kind of cap, some kind of limit. And I hope the Supreme Court sees that, and I hope that the arguments that we'll make today are going to be well received. Again, I don't know what the court's going to decide. Hopefully, after today's argument, I'll have a little bit of an update video and give some impressions about what I think the court thought, what they might want to do. But I think you and I, you watching the video and me here, we know the answer to the question. There have to be limits. The administration of justice has to be fair and even-handed, and both sides have to have the same opportunity to prove their case, once and once only. So, if you're interested in this case, you want to know more about the case, in the notes accompanying this video, we'll have a way for you to contact my law firm, Ricardo Wasylik. We're going to try and make some public information available about this case and about the outcome of this case as it goes on. And certainly, once we reach a decision, we're going to let everybody know what happened. So, in any event, thank you for watching. I'm really looking forward to the opportunity to convince the court that fair is fair, and what's fair for one side is fair for the other. Thanks, and have a great day.